Probably not because of
All right, I think we're going to get started. Thank you, everyone, for coming. Great turnout here in Denver. And on the screen, you've got Boise, Billings, and Salt Lake City. Looks like good turnouts there as well. Real quick sound check. Can everybody, let's start with Boise. Can you hear?
Yep.
Okay, Salt Lake City. You may need to figure out.
Yes, we can hear.
Great. Montana. Maybe a thumbs up.
Wave.
Okay, good. All right. Good. So our format today
Can you hear us
is.
now?
Yep, we got you. Our format today is we've got 6 micro sessions. They're 25 minutes long. We're going to take a break after each 2. So we've got 2 breaks spread in the middle. We're coming to you from these different offices, so the speakers are going to shift around. We're starting here in Denver. Then we're going to go to Idaho. And then after that, I think we're going to do Salt Lake City and Montana after that. Thanks for coming. A few announcements before we get started. Of course, our disclaimer. For CE, if you want your CE credits, you need to be signed in. CPE, there's also a form evaluation that you'll need to complete as well. If you want SHRM credit, we can handle that too, but you'll need to let the person who checked you in know about that so that we can follow up with you afterwards. If there's any questions, you can contact Sophie. Okay, a little bit of background about Holland and Hart, full service law firm. We're spreading out, including a new office opening soon. Over 500 lawyers. The symposium today is brought to you by the benefits subgroup. So a little bit about that. I don't think we have a slide on that. The benefits subgroup is 7 attorneys, 2 paralegals spread out across these offices. So you'll meet them as we present to you today. Almost everybody's presenting. And if you have your agenda, you can use that as a cross-reference to who's who. I'm Kevin Selzer. I'm the subgroup leader for the benefits group, and here in Denver, been practicing for about 13 years and working in the benefits space prior to that. My practice is mainly focused on retirement plans, health and welfare plans, and executive compensation. What I'm going to talk to you today, I kick us off, we're going to talk about health plan litigation. So most of our topics today are sort of what's top of mind. This is a big one that we're dealing with. And I want to start with class action lawsuits in the health and welfare plan space. So a lot of the litigation that we've had, when you think of ERISA litigation, has been retirement focused, especially class action litigation. We've had sort of a boom of that over the last 2 decades or so. And that litigation's largely been successful. So lots of lawsuits have been favorable for the plaintiffs, either in the finding in the courts or in a settlement. And we're starting to see that happen with health and welfare plans. So this is a topic we wanted to talk about. In the health and welfare space, a lot of the ERISA litigation historically has been individual participants being harmed. So I had a heart surgery, the plan didn't cover it, so I brought a lawsuit for the plan to claim my benefits under ERISA. Now we're starting to see the class action lawsuits pop up on the health and welfare space as well. So to kind of set the stage for this, I want to talk a little bit about that history. Most of the litigation on the ERISA side for retirement plans has been focused on defined contribution plans. So these are like your 401k plans and the like, 403b plans, where participants have individual accounts. And the predominant strain of litigation has been around complaints that the investments that were available in the plan were poor and the fees that were paid to the service providers were excessive. In defined contribution plans, those lawsuits have been successful because if the plan, for example, pays too much for services, that directly reduces the participant accounts and their benefits under the plan. On the defined benefit plan side with retirement plans, lawsuits have not been as successful. And that's because, for example, if you use the trust assets in a traditional pension plan, and maybe you paid too much for services in that plan, participants' benefit is still the same. At the end of the day, the employer has to make up the shortfall in the trust. And so the employer bears the risk in the defined benefit plan side. The question of how the courts view these health plan lawsuits, it's really struggling. Is that more of a defined contribution style lawsuit or more like a defined benefit plan? And I'm a visual thinker, so this is the chart that I put together that kind of shows you how money flows with defined contribution plans and defined benefit plans. So you can see up top with the DC plans, you have maybe the employee contributing money to the plan, definitely the employer contributing money, and then the plan assets are used to pay service providers. Ultimately, the benefits come out. And as we talked about, the risk of loss is really the participant. And on the defined benefit side, as we talked about, you have the employer only putting money in and then bearing the risk. So if you were to sort of overlay a health and welfare plan, a self-funded health plan over one of these charts, it would look a little bit like both of them. And in fact, quite a bit different from both of them as well. You'd have a participant, sometimes they pay co-pays, co-insurance, that sort of thing directly to the service provider. So there'd be a line from that individual to the green box. And then you also have some similarities with the DB plans. So just here in Denver, real quick, show of hands, who thinks the courts would view a self-funded health plan more like a defined contribution plan? Say a few hands. What about a defined benefit plan? We have a hand there too. A lot of people unsure, which is kind of where the courts have been. We have two cases that I've included today. For the most part, the courts are viewing these like defined benefit plans today, but the decisions we have are pretty limited and they're at the district court level. So we'll have to see if this advances up to the circuit court levels, if different district courts and different circuits decide differently. The first case, Nunsen, this case was dismissed for lack of standing. In this case, there's rebates from the PBM. The PBM is the pharmacy benefit manager. They're kind of like the TPA with respect to prescription drug coverage. So they're the one who coordinate the network and the costs that you pay for the drugs and that sort of thing. It's common when you have a prescription filled for there to be a rebate from the drug manufacturer back to the PBM. Sometimes the PBM passes that through to the plan sponsor. Sometimes they keep it. In this case, those rebates were sent back on to the plan sponsor, and the participants argued, hey, those are our rebates. They came from the plan's payment of those benefits and prescription drugs. The court disagreed and said, no, there's nothing by the terms of the plan that you're entitled to these rebates. So it's perfectly fine that they go back to the company. And because you were given the benefits that were spelled out in the terms of the plan, you have no harm, there's no injury to you. And so they dismissed for lack of standing. So similar with Johnson & Johnson case, this one made the headlines. Maybe you've heard of this one too. This one had some more eye-popping numbers in the allegations about some of the cost of drugs. So one of the drugs they alleged you could get for $30 at certain pharmacies, but the plan was being charged $10,000 for that drug to be filled. So similar allegations, fiduciary breach arguments against the plan sponsor. Ultimately, this one was very recently dismissed as well on the same grounds, lack of standing. So they're kind of analogizing these self-funded health plans to defined benefit plans. In this case, I think the representative for the class, Johnson & Johnson, was able to convince the court that that representative would have met their out-of-pocket maximum due to other medical expenses they incurred during the year. So even if they paid more for the drugs than they should have, they would have been in the same out-of-pocket position they would have been in had the drugs been cheaper. And so they dismissed for lack of standing as well. So at this point, what we know about the decision, there's some other cases that are similar. Most of these are coming out of the Third Circuit, interestingly enough. What we know at this point is the decisions are employer-friendly, maybe not participant-friendly, but employer-friendly. And so it's difficult right now for the plaintiffs to bring these class action lawsuits. But that doesn't mean we shouldn't care about the allegations that we're seeing. One is let's just assume that what the plaintiff alleged in the Johnson & Johnson case with the $10,000 for the prescription drug coverage was correct. Well, if the participant wasn't harmed, who was harmed? The company, because as a self-funded health plan, they have to come out of pocket for those expenses. So if you pay too much, then your plan is running more expensive than it should be. There's also, the considerations about, what's the impact of the dispute itself. It's not all damages are cash and money. I'm sure the employees at Johnson & Johnson that are aware of the lawsuit probably think they don't have a great health plan as a result of this. It can have other impacts as far as clients and other business relationships as well. And then my last point is that, again, these decisions, these cases are pretty new. We have a plaintiff's bar in the ERISA space that's very experienced with 2 decades of experience in bringing these lawsuits with defined contribution plans, and they're creative. It wouldn't surprise me if they find footing in a different circuit or with different arguments. Okay, next flavor of health and welfare lawsuits. So full and fair review cases. Under ERISA, there's required to have internal claims and appeals procedures. So the idea behind this is that we don't want to flood our courts with disputes between participants and plans. Let's have an internal dispute resolution process. And so within health plans, you have some of the most stringent claims and appeals procedures that you have under ERISA. And when participants bring disputes, they have to go through this process before they can go to court. So here's 2 examples. Both of these cases actually deal with mental health issues, which is a good foreshadowing for our next topic. But in both of these cases, the court found that the plan hadn't fully and fairly considered the case and overturned. So claims and appeals procedures are very important for a number of reasons to monitor for self-funded health plan sponsors. One is it's an opportunity well, let me back up and say that in most self-funded health plans, the claims and appeals administrator, the fiduciary that's in charge of determining those, is the TPA. So it would be a United, a Cigna, an Aetna, a Blue Cross. That's typically delegated from the sponsor to the claims and appeals administrator, the TPA. Under ERISA, you can never delegate all of your fiduciary duties. So even when you delegate, you still have a duty of oversight. So understanding what's happening within your plan on its claims and appeals helps fulfill that oversight responsibility, helps reduce the risk that you'll be liable as a fiduciary for that. Not only that, it can help identify issues with your plan document drafting. We've had cases where we've looked at the ways that the TPA is handling claims and appeals and realized that we needed to update the SPD to match the operation of that. So our lessons learned and recommendations here are monitor claims and appeals. Typically, contracts with the TPAs have provisions built in that allow for you to do certain audits. So you can take advantage of that. If you get demand letters from third parties saying the plan administrator, the TPA, isn't fulfilling their duties, you have a fiduciary duty of oversight to look into that and investigate and look at that. Mental health parity, real quick, an overview of what this law is. It's been with us for about 17 years. What it does, kind of big picture, is it says that if you offer mental health and substance abuse benefits in the self-funded health plan, those benefits have to be on parity, generally not worse than the medical surgical benefits that are offered under the plan. And they measure this 4 different ways. One, there's a prohibition on annual lifetime limits. The second is there's certain financial requirements, so we can't have higher copays for substance abuse than we can for medical surgical benefits, for example. Quantitative treatment limitations, these would be restrictions on access to care or care that you count in numbers. So your benefits with respect to residential treatment is capped at $10,000. That would be a quantitative treatment limitation, a cap on the number of days you can visit a facility, that sort of thing. The last one, non-quantitative treatment limitations, is The big one that this is where we see DOL enforcement today. It's also where we see a lot of the participant lawsuits, and that's non-quantitative treatment limitations. This is anything that isn't counted by a number, basically. So examples of this would be you require prior authorization for too many of your mental health substance abuse benefits compared to what you do on the medical surgical side, or your approval or overturn rate for appeals is too high or too low on the mental health substance abuse side than it is compared to the medical surgical. So with the CAA passed in 2021, we have a requirement that large self-funded health plans conduct a analysis of their NQTLs, the non-quantitative treatment limitations. So this is something that the DOL actually is required to audit each year. And it tends to be, like I mentioned, where we see the lawsuits as well. But here's two examples of lawsuits that we've seen on the mental health side, or at least one lawsuit on the mental health side. That's the Ryan S. The United Health Group. These related to substance use disorder claims. This case was ultimately dismissed in favor of United, but this is similar to what we tend to see on the mental health parity dispute side. The other relates to a large settlement that was announced by United several years ago now, after the DOL investigated and found that it didn't have sufficient mental health parity protections. So our lesson learned here is we need to be reviewing and focusing on mental health parity in our self-funded health plans. A lot of sponsors are in a really difficult spot with this NQTL analysis that I mentioned. It's difficult to get the data from the TPA that they need to do the analysis. The TPAs will not do the analysis for them. And so something that we're working a lot with our clients to get put in place so that if they're audited by the DOL, they're ready. The law, when it was first enacted, you were required, it was something like 60 days after it was enacted to have that analysis done. The DOL was pretty lax if they came in and audited and it wasn't ready. That's not the case now. They expect you to have it. Okay, lawsuits against TPAs. So we've talked about participants suing the plan either on an individual basis or a class action basis. These are lawsuits where the plan sponsor itself is suing the TPA in the plan. A lot of the times the plan sponsors are alleging that the TPA is acting as a fiduciary under ERISA, has fiduciary duties, and they've breached those. So far, the courts aren't very receptive to that argument. So all of these cases show you basically the court saying that in the alleged poor behavior, the TPA was not acting in the capacity as a fiduciary. So they may be a fiduciary for claims and appeals purposes, but not for purposes of the administration being challenged in these cases. The second set of lawsuits against TPAs that I have here, I wanted to highlight a couple things about them. One is Kraft-Heinz. You may have heard about this one, and the Owens and Meyer case. Both of these cases, one main component of the allegation was that the TPA wasn't handing over claims data. That may be surprising. As a self-funded health plan, the employer ultimately has to pay all the claims, right? So you would think they'd be able to get the data of what they had to pay. And in these cases, the TPA wasn't handing over that data, and so they had to bring a lawsuit. Now, both of these cases were voluntarily dismissed, and because they're not class actions, if there was a settlement, the settlement's not public, so we don't know how these resolved, but presumably maybe they were given access to that data. The lesson to be learned from these other cases is that if we have a dispute with our TPA, argument of fiduciary breach isn't likely to go very far. So what's going to govern the contract that we've negotiated with the TPA? It's really important that we negotiate those contracts well on the front end. This is where we spend a lot of time, and we have strategies to try to get better provisions in at times the negotiation process when you're hiring a TPA to do that. But it's something that needs attention. And we have had success in getting provisions in these contracts that say we have a right to the claims data. It's not proprietary or protected information, but that needs to be in the contract, even if we have to pay to enforce some of those rights. Okay, I think we're doing okay on time. All right, my tips for 2025 on the health plan side. So first tip is it's time to establish a good fiduciary process. Most plan sponsors on the on the retirement plan side are pretty well organized. And we've had committees, they meet quarterly. We document our fiduciary duties and what we're doing to evaluate investments and providers. We're not so good on the health and welfare side. So I think it's time that we establish that same governance principle for self-funded health plan sponsors. The benefits here are, okay, we're managing that litigation risk that I talked about. We've talked about this a lot on the retirement plan side for years, that one of the keys to sort of not being sued is not looking like the low-hanging fruit. So if you just have good structure and governance as a starting point, it's likely that may dissuade a plaintiff's attorney from looking further. Consistent decision-making. So having a group of people that meet helps provide continuity in decision-making. It also helps with turnover. So if somebody leaves and that person was responsible for running RFPs, well, what's the next one look like? Probably a lot different than the one before it. If the committee is handling enrollment eligibility appeals, which are technically not covered by ERISA's claims and appeals procedures, then that's another benefit of having groupthink and sort of consistency in decision-making, because those types of decisions could be challenged under other bases of employment discrimination and the like. And then lastly, it's a lot different than where we were 10 years ago. There's lots more responsibility put on the plan sponsor for administering the plan and complying with law that the TPAs aren't helping with. So mental health parity is an example. The committee can be in charge of making sure that that analysis is being done and updated regularly. I mentioned the eligibility enrollment claims, and then RFPs and vendor oversight. Kind of and ensuring you have a formal function for that. Okay, tip number 2, I mentioned most contracts have audit rights built into them. So there'll be like maybe 300 claims that the plan sponsor can audit at no cost. Has a right to do this maybe each year. These are provisions that we negotiate into the contract. A lot of times these are exercised. We are finding more and more often that there's mistakes with administering these plans, and claims are being overpaid. So the plan is paying more than it should have been. And so these exercising these audit rights can help uncover that. Tip number 3, negotiate key provisions of contracts with TPAs during RFP and RFI process. So as I mentioned, one of the issues with the RFP process that we often see is we select a vendor. Maybe we've received a copy of their sample contract and maybe we've looked at it. If we've selected them and we start implementation, and that's when we're negotiating the contract with them, they know we're pretty much tied to moving forward with them. So we have very little leverage in those circumstances. There's things that you can do to enhance the types of provisions and things that you can get the TPA to agree to if you get them to agree to that while they're still trying to win the business. And tip number 4, review the certificates and SPDs annually. There's changes in these provisions. Sometimes these SPDs, the certificates that are generated by the TPAs, aren't customized for your workforce, and those need to be adjusted. It's just a good practice to look at those each year. So that's all I've got. Any questions? Okay, I'm going to turn it over to Alex.
Okay, so I'm Alex, and I'm going to talk about benefit plan mistakes that happen and some of the programs available for fixing it that have governmental approval or governmental blessing at least. So the 4 main areas of correction programs are from a combination of the DOL and IRS. There's delinquent filer voluntary compliance program, the voluntary fiduciary correction program, the retirement plans correction program, and then 409A. So the first one I'll talk about is the DOL's Delinquent Filer Voluntary Compliance Program. It's utilized for addressing unfiled 5500s. And unfortunately, it doesn't also apply to correcting incorrectly filed 5500s. And those need to be resolved by just filing an amended 5500 and hoping the DOL doesn't necessarily care about the mistake. And the reason that this program is extremely valuable is the statutory penalty for an unfiled or incorrectly filed 5500 is pretty astronomical at over $2,600 a day. Granted, the DOL may not necessarily seek that amount, but the penalties for utilizing this program are substantially lower. So at $2,000 per plan for 1 year, maximum $4,000, it's a lot cheaper to simply voluntarily file the unfiled 5500s and know that it's done. The DOL can't seek any penalties for unfiled 5500s, especially because there is no statute of limitations that would apply. And lower penalties would apply for smaller plans, so it may be even less expensive. And it's entirely possible that some of the unfiled 5500 issues are related to just oversight of not including a health and welfare benefit within the wrap plan accidentally, or from an acquisition and not fully accounted for the plan that's coming over or it being terminated in advance. So plenty of unexpected ways to run into an unfiled 5500, even though for like a 401k plan or the group health plan, those usually will end up getting filed without missing it. It's more likely the random unaccounted for plan where this comes up. And the next correction program I'll discuss is the DOL's Voluntary Fiduciary Correction Program. And this is available for certain fiduciary issues. The DOL has issued guidance providing very detailed rules for how the program operates and which types of issues can be corrected through it. And some of the most common uses of it are the late remittance of participant contributions and loan repayments, and then issues with how plan assets are utilized, such as issuing a loan but charging below market interest, because then the plan isn't fully being made whole and receiving appropriate compensation, paying too much for an asset or selling it for too little, or transactions with a party in interest where even if the transaction is completely fair and at fair market value, ERISA's fiduciary standards kind of frown upon those transactions with parties in interest and running into prohibited transaction issues, which then on the IRS side can create excise tax liability. And for the most part, utilizing the VFCP program requires a DOL filing. Fortunately, the DOL recently introduced a self-correction component for certain errors, but even though you'd think self-correction doesn't actually require government involvement, it still requires filing a notice with the DOL, which may or may not defeat the purpose of it being self-correction. And for some of these corrections, it is a bit limited for when self-correction can be used rather than the full VFCP filing. So like for late contributions, the late contributions have to go into the plan within 180 days of when they should have been contributed. And typically the DOL views contributions needing to be paid to the plan within 7 to 14 days. So there is a bit of a rush and urgency for getting on top of this. And also the lost earnings are capped at $1,000, which depending on how long the money has been kept outside of the plan, it may be possible to blow past that figure if it's fairly large payroll or if contributions have been missed for multiple payrolls. One of the useful features of the program is there is no filing fee, and the use of it allows you using the DOL's online calculator to calculate the lost earnings that are payable to the plan, which is usually going to be a lot less than what the lost earnings would be if, for example, on the retirement plan side was based on the highest earnings rate of investment or the plan's earnings rate. So it could be a difference of 4 or 5% interest versus 15% interest. But that varies based on what the appropriate earnings rate would be for the plan. And using this program does provide a no action letter from the Department of Labor if it's approved, and which is helpful in the event of a future DOL audit so that the DOL can disagree with the correction approach that was taken if an employer chooses to just self-correct and not go through the program, which sometimes may be the more practical solution for a variety of reasons, including the DOL will usually have some level of back and forth with VFCP filing. So that can be time consuming, can involve documentation that isn't readily available. So there is a balancing act of deciding whether this program is worth using or not under given circumstances, even though it's still worth at the outset evaluating, does the issue fit within the program, or does it make more sense to just self-correct and acknowledge the audit risk from the DOL. And now I'm going to switch over to the IRS side of things, which is focused on retirement plans. So for a while, the IRS had various iterations of the Employee Plans Compliance Resolution System that can be utilized for fixing issues with qualified retirement plans, such as 401k plans, defined benefit pension plans. And it's currently detailed in a revenue procedure from 2021 that the IRS should be updating at any time now and issuing a new one, but who knows when that's going to come out. And the current version is an updated version of the various previous iterations, with the program having evolved over time. And there are 3 components of the program: the IRS's technical view, but I guess it's really only the self-correction program and the voluntary correction program that are actual corrections with a choice. Starting with self-correction, unlike the DOL's self-correction option, this truly is self-correction, no IRS involvement. Ideally, employer would want to document the correction so that there's something in the record if the IRS ever came looking on audit, or for the plan's auditor to document that the issue has been corrected. And fortunately, self-correction has been expanded in recent years because of Secure 2.0 and the IRS's guidance about that. And presumably, whenever the new IRS revenue procedure for this comes out, they will actually detail the expanded self-correction and how it applies so that it isn't so much making assumptions for what seems to fit within it. And historically, self-correction's been available for insignificant operational errors, and that had a time limit, usually going back up 3 years. So there was a bit of urgency for identifying the error, which can be hard for certain just recurring issues that can go unnoticed, especially if it's a relatively small dollar amount or an isolated incident. And then Secure 2.0 expanded to cover eligible inadvertent failures, which no longer contains a time limit. So there is a bit less urgency, but it's still important to get out in front of an issue when it's discovered and figure out the correction approach, because there is always the risk that the plan could be subject to audit. And for purposes of the plan's 5500 audit, it's better to have something corrected rather than the plan's auditor picking up on the issue and wanting a detailed explanation and getting involved in the correction. Just easier to get out in front of it. And one of the important nuances with utilizing self-corrections that the IRS requires plans to have established policies and procedures designed to promote compliance. So while this normally is not going to be an issue, there can be those unique circumstances where that does become a concern, which could end up forcing IRS involvement, which is one of the reasons why it's usually better to just, once an issue is identified, working on the correction. So, and having the procedures in place, such as committee meetings, reviewing how the record keeper is generally performing its responsibilities, so that there are policies and procedures in place, and it's more likely to catch issues while they're relatively small and insignificant and easy to fix. And the next part of the IRS program is the voluntary correction program. And part of the key with getting out in front and identifying errors is that a VCP filing is not available to plans that are under IRS audit. So what could be a relatively straightforward VCP filing for an issue that can't be self-corrected wouldn't be available if the IRS just shows up for an audit before a VCP gets filed. And this does have some level of payment to the government, with the IRS filing fee currently ranging from $1,500 to $3,500, which for most plans will end up being the full $3,500 filing fee. So it's some cost beyond the attorney's fees associated with preparing the filing. And another consideration is this is a really lengthy process. Sometimes it takes the IRS well over a year to just respond with initial follow-up questions after a VCP is filed. The longest that I've encountered recently has been 2 years from filing for the IRS to initially respond. So that, but then I've also seen some with a 3 to 4 week turnaround from the IRS where it was extremely straightforward. So no rhyme or reason to why it might take that long. And a common use for VCP filings are corrections that would ideally be fixed with a retroactive amendment, but because of what the amendment does, it can't just be done through self-correction. It actually requires the IRS approving it and being convinced that the retroactive amendment is appropriate under the circumstances. So that's probably the most common use for a VCP filing when a retroactive amendment is desired for something where the IRS's safe harbor approved correction from their guidance would be making a corrective contribution that may be substantial. And successfully completing this provides for a compliance statement from the IRS that provides formal documentation of the IRS signing off on the correction and knowing that it can't be subject to challenge on a future IRS audit if the IRS ever came around on it. And then technically the last part of the program is audit cap, which is when the IRS comes in and discovers an issue on audit. And that's why it's usually better to resolve the issue either through self-correction or filing a VCP rather than having the IRS discover it on audit, because in addition to the correction, the IRS can impose a sanction normally, and depending on the magnitude of the error and how broadly it affected plan participants, the amount of money at stake, the sanction can be fairly substantial. And with issues involving plan qualification, the IRS does have the threat of disqualifying the plan, even if that doesn't necessarily happen all that frequently, which can make it tougher to negotiate with the IRS over what the correction should be, what the sanction should be, compared to even if the IRS doesn't necessarily agree with the proposed correction on a VCP filing, there is a lot more room for back and forth with the IRS to try negotiating compromise that even if it's not everything that the employer would like, it's still less than the full corrective contribution and what the IRS would like and ask for if the issue were discovered on audit, and what would apply if the full safe harbor correction was followed initially with making a potentially sizable corrective contribution. So now I'm going to switch over to talking about 409A corrections, which are primarily related to non-qualified plan issues that come up. And 409A penalties can be extremely harsh, and besides it affecting the employer, also have the potential for the employee to be subject to 20% additional tax penalty and interest besides income tax on what should be deferred amounts becoming due. So it can be extremely undesirable. And this most frequently comes up in the context of impermissible changes to non-qualified plan, deferral elections, or payment timing elections. And some of these issues come up completely unintentionally just based on circumstances that are unique, not fully contemplated within the plan document, or because of the individual participants' unique circumstances. There just isn't a ready solution on hand and built in. And it's important to identify these errors when they come up, because certain instances have to be corrected relatively quickly, especially when they involve someone who's considered an insider. So that could require correction by the end of the year after the mistake is discovered, which doesn't necessarily provide a lot of time in circumstances where it's tough to detect the error. It goes unnoticed. And one that, I guess, challenges with the IRS's correction guidance is that this is the only formally approved guidance from the IRS on correcting 409A errors. So there is the risk that not utilizing the steps outlined in the IRS's guidance, which is over 15 years old at this point and doesn't necessarily contemplate the evolution of 409A interpretations since shortly after the regulations were issued. It's usually a lot safer to just go along with the outline correction guidance rather than doing only a partial correction, because some of the annoying features of it is it does require the employer to file a statement with their tax return, providing some limited detail on the 409A error and correction. And certain circumstances, the participant also filing a statement with their tax return, which no one wants to do under any circumstances. And also in terms of, even if the statement is relatively benign, just needing to inform the participant of the need to file the statement with their tax return can be extremely unappealing. And one way of generally avoiding the participant statement requirement is if something can be corrected in the same year, then it's unlikely to hit the participant's tax return. So there wouldn't be any need for the participant to file a statement with their return, which can make the participant communication, employee relations aspect a lot easier to deal with. And now we're going to have a 10-minute break, and the next segment is going to be our no dumb question section, which will have some polling questions with a slide for you with an app to pull up on your phone.
This is how you'll answer questions as we go. So after the break.
right, guys, we're gonna get going in 30 seconds or so. People want to grab a drink and get ready to talk about the next session. All right, we are moving on to there is no such thing as a dumb question. My name is Ben Gibbons. I'm a partner here at Holland & Hart. And this is our attempt to kind of add a little bit of an interactive session to hopefully keep this a little lighter. And what we've done is we've come up with about 30 or so questions. And each of us have been assigned questions to answer. And we've divided them up into several kind of voting group. And our hope was, if technology works, that we within each group of questions, we'd discuss whichever one gets the most votes, and then we'd move on to the next. We'd probably cover 4 or 5, maybe 6 questions, depending on time. And we got 1 vote anyways. And yeah, we'll go from there. So let's give this a minute and see how it works out. And if Slido ends up failing us, we can always just folks in the Boise office can pick the questions. At least most people know what ERISA is, which is great. It's gaining popularity. Bernie, do you know how many total people we have, roughly, amongst all the RCPs?
We're about 20 per office.
Okay, I'll give it another 15 seconds. I see we got 31 responses, it looks like so far, which is pretty good. And I think we've got a clear winner, I think, probably at this point. So is your 401k target date funds, or are those funds under attack? And I think, Beth, that one is yours. So turn it over to Beth Nedrow to answer this one.
Yeah, if that is going to be a good test of the sound system. So can everybody hear me in the other offices? I'll assume so. So 401k target funds, if you Google, lawsuits, 401k target fund lawsuits, you'll find that there is a flavor of lawsuit that's out there where the plaintiff's bar is alleging that certain suites of target date funds that plaintiff sponsors are offering are high fee or low performance. Personally, I don't think they're under attack any more than any other kind of fund offering or service under a 401k plan. The unfortunate reality is that's a hot topic for litigation, and it's just something you have to monitor. It's also 100% true that target date funds are overwhelmingly the most common and what most fiduciaries see as the safest QDIA, your qualified default investment alternative. So they're the most, employees seem to love them. They're a lot of offerings, but you have choices. And so you're probably in good company if a target date fund is your QDIA, but you do need to monitor it like you do every other fund. You should know the difference between to and through. If you don't, put that down in your notes and take it back to your investment advisor and at your next investment committee. Say, our target funds, are they to or through? And have that discussion. That's a good discussion to have. So under attack, not any more than any other 401k investment feature, but yes, that's a hot one of the meaty topics that your investment committee should be reviewing.
Great, thanks, Beth. We'll go to the next slide. And I should add too that any questions that we don't get to that you want to hear the answer to, feel free to ask Bret, myself, or anyone in the other offices, during the break or at lunch, or send us an email. We'd be happy to talk about any of these. All right, on to round 2. And we'll give it a minute. Uh-oh. Technology challenges. Is it possible to go back to round 2? Or is that last break?
1 second.
the interactive, responses and polling is always is great when it works, but
We didn't like the smoker questions.
exactly. All right, we've got 20 or so. So let's we kind of got mixed up there. Why don't we just go with the first one here? The answer to the smoker question is yes, but there's some guardrails around that. But let's go with the timing for contributions. That one is mine, and this is something that has been kind of a challenge to employers for a long time. In the 20 plus years that I've been involved in the benefits space, it's been a hot button topic and issue with the DOL to ensure compliance. And the general rule for the remittance of participant contributions, this includes loan repayments as well, is that contributions need to be remitted within 15 business days the following month from which they were withheld, or as soon as they can reasonably be segregated from employer assets. And for a long time, there was confusion around this 15 business days the following month, where folks thought that that was the standard. And as long as you got them in by that 15th business day next month, you were okay. And the Department of Labor has spent now, again, at least a couple decades trying to educate plan sponsors that is the outside limit, and that as soon as they can reasonably be segregated from company assets, that is when those contributions are due. And actually, before I dig into that a little further, I do want to say about, I don't know, so over 10 years ago, less than 20, they did put a safe harbor in for small plans. So if you're a plan that has less than 100 participants, and there's a 7 business day safe harbor, so you're not bound by this greater than the 15 business day, or as soon as you can segregate, you have 7 business days. So that the idea behind that is for smaller companies that might not have the administrative personnel to get those contributions as timely, they have that 7 business day safe harbor. Everybody else, if you're over 100, you're at the general rule. And this whole the idea of as soon as you can reasonably segregate those assets, a couple of things to keep in mind is that Department of Labor, if they do audit plans, they always look at this and they pay close attention as to what the plan is established kind of for their typical remittance schedule. So if you're remitting, let's say, contributions 2 days after every payday, right? So you have the pay date, 2 days later, the contributions go in. Even if you have those, let's say you accomplish that in maybe 10%, 15% of your payrolls per year. When the Department of Labor comes in and looks, they're going to say, well, you've shown, since you did it 10% of the time, that 2 days is what's reasonable, and that's when you can reasonably segregate those assets. So the fact that the other 90% might have taken 3 days or 4 days, they're going to say, you already demonstrated you could do it earlier. And they'll oftentimes assess lost earnings on those. They'll make you contribute lost earnings, and it ends up a huge nightmare because you have to put in, $10, $15 to spread out amongst potentially hundreds of people. Everyone gets, really pennies. And you have to, get that into accounts. If people have left the plan, you have to create new plans, put that money in, and you got to kick their assets back out. It really is a nightmare. So I guess the one takeaway on this particular question is, know that 15 business day, that is the absolute outside limit. It's as soon as you can reasonably segregate those assets, unless you're a small plan. And again, if we're at the general rule, consistency is key. Don't try to, if you can do it one day, like once in a while, don't do it in 3 days all the time. You can show if you ever get audited, hey, look, we do it 3 days. It's all automated. You won't be challenged most likely in those circumstances. All right, let's move on to round 3. I don't know if those previous answers got saved, but there was a few votes on that one. All right, it's a good sign. At least those responses didn't disappear. All right, rescinding employers' health coverage. I didn't think that would be towards the top, but we'll see. We'll give it another 10 seconds. Let's see which one wins here. Okay, if we go back to round 3, and we'll go to, actually, I have the list here, so I don't know if they're in the same order. Of course they're not. But that was the, can we make an exception to our health plan, I believe, right? That's the winner. To cover certain excluded benefits or ineligible individuals. And Brenda Berg, I think that one is yours.
Great, thank you. Okay, we do get this question a lot of people call us and they say, a lot of times it's an eligibility question where somebody got in late on the enrollment where they're supposed to put it in for their new baby within 30 days or whatever. But sometimes it's also other exceptions, like can they cover a drug or something like that? It's a very sad story. You want to help them, and employers are usually really want to help their employees on that. And unfortunately, our general rule would be no, don't make an exception. Why not? Because you have a fiduciary duty to follow the terms of your plan. So that's the bottom line. But also, if you're making an exception, you're setting a precedent. So you're setting a precedent of what then someone else comes along and what are you going to do something different for them? And of course, the person you approved might be somebody who was high compensated at the company, and that also can be discriminatory and have discriminatory tax consequences. Another big reason on self-insured plans is you typically have stop loss insurance. Stop loss is probably not going to make that exception for you. So if you're making an exception, there's a good chance you're going to end up covering it yourself. It's possible to check with your stop loss, and they might say that's a reasonable interpretation, but that's a very important thing to think about as far as your risk that you're taking on when that goes. So what we would prefer instead is amending the plan if it's something that you want to do. You can say, we do think we should cover that drug. And I'm talking about a self-insured plan here, because if you're an insured plan, your ability to make exceptions is really limited. You're going to have to follow the insurance company. But in a self-insured plan, you can amend the plan document. You can say, we do cover this. Something to note there, you are supposed to, there are some requirements to prospectively notify participants in some cases about amendments. We're not too worried about that when it's something that's favorable to participants, but it is something to know. Ideally, you don't need to amend it ahead of time. When we do get the eligibility determinations, I would say there's probably, sometimes it's the employer's fault, right? That somebody didn't sign up within 30 days. Sometimes the system didn't work, and you can tell that they went in there and tried a bunch of times, or they submitted it, but and then they talked to you about it, and they really were diligent in trying to get signed up but couldn't. So in that kind of situation, you're probably on better footing if you make a so-called exception, because really it's an administrative error is what we would think of that as, more than an exception. So if you want to do that, there's also a concept out there in case law of tolling a period. So like if somebody was incapacitated, if they're in a coma or something like that, that might be a reason you might give them a longer time period. Again, I would always recommend working with notifying the stop loss carrier so that you're not left holding the bag on that. Those are generally the considerations that we look at for any exceptions.
Great, thanks, Brenda. All right, on to round 4. There we go. We've tried to mix these up too, where there's kind of a mix of retirement and health and welfare questions in here, so they're fairly varied. I gotta wait another little bit. We need a tiebreaker here. There we go. I've got 30 every time we're ready to call it. Okay, let's go with the first one there. How do we keep track of former employees, and what do we do if we can't find a participant? And that's actually Brenda once again. Brenda?
Okay, this one could be a long one, but I'll try to sum it up somewhat. How do you keep track of former participants? Well, if you're terminating the plan, there is some specific guidance of things that you can do, and where eventually you get to turn it over to the PBGC, even in a defined contribution plan now, even though the PBGC was historically for pension plans. So there is, but before you can do that anyway, you're going to have to go through all these other search steps. But the problem that most people are running into is they're not terminating the plan and needing to pay out. It's just on an ongoing basis where they can't find people. They can't find them to make their required minimum distributions, or even just to cash the check, and especially small account balances, cashing the check. Now, of course, if you've got a small account balance now under $7,000, $1,000 to $7,000, you can roll it over to an IRA. So as long as you have their social security number and such, you can set up an IRA. And the DOL is fine with that. The DOL has been auditing missing participants pretty heavily, especially in pension plans. So they're very worried that people are going to be missing out on their benefits. If they worked somewhere for a while, didn't even realize they had a benefit, and it's happening a lot. And the problem is people aren't figuring that out, until it's time to start the benefit when they're age 65. So, or even later than that for required distributions. So that they're not figuring it out until then. Now these people have been gone for 20, 30 years. It's very difficult to find people after they've been gone that long. So my first best practices thing to do would be try to catch this sooner. When you start getting missing, you start getting things returned, and your record keeper can track this, that's the time to start looking. So then the question is, what should you do to start looking? The DOL, Department of Labor, does have guidance on this about what they recommend, the steps they recommend you take. And there's certain steps that they say are the reasonable steps that they say you need to do at a minimum. So at a minimum, they want you to send it out certified mail, just so you can show you did it. I actually sometimes say they'll also send it the other way, because just regular mail, because people don't always pick up certified mail and it seems scary. So I think you might be more likely, to find somebody with not certified.
Could you do proof of sending?
Yes, exactly. If you aren't using certified mail, that's a great idea to do, is proof of sending. So have a process that shows we keep track of anything that gets returned.
Okay.
So we show this was sent on this day, and we keep track when it gets returned. And that way you know who's missing. And what you want to do is work with your record keeper, because they'll have a system that they use. And you want to set up a missing participant policy. Very important. Anytime you have a policy, follow your policy. So that's a key point. But it's good to have a missing participant policy that says exactly the steps that you're going to take, and then put it in your services agreement with your record keeper that they're going to do all these things for you, like send it out, track it, any missing mail, any mail that comes back. Then they're going to go to the next step. Well, the next step is where I think it comes a little bit of a tension between the employer and the Department of Labor sometimes. They say to start with, check related plan and employer records. Okay, you probably did that. But then they say, check with the designated plan beneficiary. And this is where in the audits, the DOL will come in and be, you should be calling up, sometimes they go really far. Like, you should be calling up the person who sat next to them to see, do you know where so-and-so is? I mean, can you imagine if you got a call like that out of the blue? Oh, I'm an employer. He's owed some money. Can you tell me where he is? You're not going to tell them. And so I just don't think that's realistic in today's day and age. So sometimes we do have tension with what the DOL thinks is realistic versus what is probably really realistic. But you should at least look with the plan beneficiary, because they probably know, if they had designated someone, they probably know where the person is, if they designated someone. You can use free electronic search tools. Probably all seen, we have the internet now where you can find a lot. So all those things they said you should do with them, no matter what. After that, you should consider the size of the account balance. Think about what it's worth, the cost, whether you should go maybe have a locator service or go to a next level of going farther. So, like, for example, Lexus has a service. We have a service. Sometimes we have some employers that contact us with their missing participants when they get down the line to this stage. And then we run it through this search, and we often find it in the death records. The record keepers also check Social Security death records, because that, especially in pension plans, can be commonly what happened, is that they died. So after you go through all of this, if you really end up with a true missing participant, you've done everything except for maybe hired a private investigator, probably not going to be justified in most cases. You can put language in your plan document that when it comes time for required distributions, for example, that it can be forfeited. If they show up, the account would be reinstated. The Department of Labor doesn't like that, but they've acknowledged that. So those are all the steps you could do. On an ongoing basis, how often should you do those steps is always really the big question. You probably should just do it once and forget it. You would check again in a year or whatever your policy says it's a reasonable period. So I'd recommend doing all of that. And there is just a couple weeks ago, they came out with some new guidance saying you can, for account balances that are 1,000 or less, you could escheat to the state. Historically, that is not something that was really, they kind of frowned on that because they would rather have had you turn it over to an IRA. But now So it's a limited thing. It's just gonna be for cash outs, you'd go to an IRA 1,000 to 7, but for 1,000 and under, it can be hard to find an IRA provider. So there are some rules now where you possibly could eschew to the state. There are requirements on the program and that it has to meet in order for you to do that. So, you have to jump through the hoops, but just one more option for dealing with this.
All right. Thanks for that, Brenda. On to the last round. And again, like I said before, if anyone wants to chat about any of these other questions later, we're happy to do so. Again, we'll only get 8 responses, so we'll give this another few seconds to get a little higher. What we've learned is this Slido app must automatically somehow advance the slides after a certain amount of time, I guess. All right, looks like we'll go with the first one there right now. How long do we need to keep plan records for? We've only got a few minutes, but this isn't really that long of an answer. This one's mine again, and there's kind of a couple different rules to be thinking about, or standards to meet. One, in ERISA, there is a requirement that plan sponsors keep all the kind of necessary documentation they need to support their 5500 filing for at least 6 years from the date of the filing. So, that's going to be obviously not only the 5500s themselves, which live on, as you guys know, online in the Department of Labor's database, but also, things like non-discrimination testing for the year, maybe payroll records, contribution records, trust statements, anything that you might need to support the information that's on that Form 5500 filing. So 6 years is kind of the minimum standard for benefits documentation. The answer that a lot of employers don't like is that, particularly with respect to retirement benefits, where there's any sort of benefit that we need kind of the historical documents to prove that benefit or determine the benefit in the future. So anything to do with eligibility, vesting, contributions, certainly any accruals in a defined benefit plan. That sort of documentation really should be kept for as long as you need it, which is really forever until that participant maybe has cashed out their benefits for some time and has moved on, is no longer in the plan. And that used to be something we'd get a lot of pushback from years ago when things were more paper and companies didn't want to, retain reams of paper. Now, I know that companies would like to maintain things for a short amount of time than indefinitely, but at least from a storage perspective, it's easier. But as far as kind of your forever file, certainly plan documents, just because you've restated your plan, don't get rid of that old plan document. There might be some provision that didn't make it in the old one or only applies to certain people that isn't captured in that new document. So we want plan documents, summary plan descriptions. You don't have to keep discrimination testing forever, or necessarily remittance files, things like that. But some sort of payroll records are a good idea, because again, that also a lot of times if there's eligibility based on years of service, hours, any sort of counting, that's usually in there, and certainly compensation and contributions are found in those payroll records. Again, you have to keep them all, but keep, maybe that last payroll register of the year that's got year-to-date numbers on it, for each of your payroll groups. That's something you might want to save on an annual basis and kind of keep that forever. Also, definitely participant deferral elections. That's important. Distribution documentation, loan documentation, things along those lines. And for the health and welfare space, kind of depends on the plan. There's less, right? Because it's not, if you're typical like a health benefit or whatever, right? You're not gonna need to retain that documentation forever, because they're gonna, get their benefits in the year of service right into that plan, and then next year it's kind of there's not that accrual of benefits or account balance we have to worry about. So really anything, especially when it has an account balance or again, an accrued benefit, that's when we really have to consider just keeping records, unfortunately, forever. All right, that's it for the Q&A piece. I'm going to turn over to Bret to talk about the current regulatory landscape for benefit plans, which is changing every day.
Yeah, thanks, Ben. I'm Bret Busacker. I'm employee benefits attorney here at in the Boise office, and I know quite a few of you. I've been doing this, not in Boise and not at Holland and Hart, but I've been practicing law and doing employee benefits work for 25 years. And one of the things that I spend a lot of time doing is working with plan fiduciaries, individuals or committees that are responsible for kind of overseeing the general governance of a plan. And so that's actually one of my favorite things to do, is to do these governance meetings. And then I typically will provide some type of kind of insight on what you should be doing as an employee benefits fiduciary, whether you're on the governance committee or maybe you're just in the HR department. But you should be able to understand and kind of know what your responsibilities are, particularly as a fiduciary of a health plan or of a 401k plan. And so unfortunately for fiduciaries, if you've been doing this a while, you know that the world has gotten really crazy. And there's just a lot, just like everything else in governance in the United States in particular, things are swinging back and forth in terms of what rules exist and what compliance expectations there are. And so there's this case that came out in 2024. It's a US Supreme Court case. And I thought it was worth sharing with you all because it does change a little bit of the paradigm in terms of evaluating, how to comply with benefits laws and how likely our benefit law is going to continue to change and swing back and forth. And so the topic today is to talk a little bit about how the court system interacts with federal agencies in evaluating whether or not a federal regulation, sometimes I'll call it a rule, but how a federal regulation is created and interpreted from the statute. So Congress creates a statute, and then a lot of times those statutes are, they require a lot of enforcement. So you might have a statute that's, 30 or 40 pages long, but the regulation or the rule that actually impacts you all as individuals, and whether it's the way you live or how you run your benefit plan or how you run your country, you might have a 30-page statute, but the regulation may be thousands of pages long. And so what really is impacting you as a fiduciary and you as a plan sponsor isn't necessarily the law, but it's the actual rule that the agency creates to kind of bring that law into life and actually execute on that law. And so the courts have a role to play in that rule-making process, and they evaluate whether or not an agency has appropriately carried forth the law and turned it into rules, and whether that agency had acted reasonably, both in the process of creating that law, but also in interpreting the statute, and whether that interpretation could be found, what they say, found anywhere in the law. Has the agency created a rule that can be found anywhere in that law? And if the court concludes that the agency's actions were arbitrary and capricious, either in the way they created the rule or how that rule interprets the law, then those regulations will be struck down. And so this is a hot topic. The issue started really in the 1930s with the Administrative Procedures Act. This was FDR was concerned that there were a growing number of agencies, and the agencies were starting to impact the role of the division of powers between the executive branch and the congressional branch. And so FDR wanted to create this Administrative Procedures Act to make sure that when an agency created a rule, that it was doing it in an appropriate process, and that rule didn't essentially give that agency more power than it should have, both with respect to kind of the balance of power within the branches of government, but also the way it impacts individuals' lives. And so that was the Administrative Procedures Act. And that law went along for quite some time. And then in 1984, we had this case called the Chevron case. And that is kind of the start of what I'm going to talk about. So we're going to get to the end, and we'll cover the things like the fiduciary rule and the ESG and how Loper-Bright has changed the way these rules may be enforced or impact you as plan governance. So why don't we change slides? Okay, so Loper-Bright is kind of a crazy case. It actually is a fish hatchery or fishing case. It arises out of the wildlife and regulations of fishing businesses and how fishing businesses conduct their activities. And in that case, some boat companies that were running a fishery business challenged whether or not they had to pay to have federal regulators on their boats monitoring their fishing activities. And so that's the background of this case. It has absolutely nothing to do with ERISA. But what it does have to do is the role of the Supreme Court versus agencies in determining what regulations apply to you all as benefits committee members or as plan sponsors. And so getting back to the Chevron doctrine, the Chevron doctrine was the first case to interpret the Administrative Procedures Act and create a standard of review. And essentially the Supreme Court in the Chevron case ruled that when a regulation is interpreting a statute, so long as that regulation's interpretation of that statute wasn't arbitrary and capricious, that statute, that regulation could stand. But if the rule was ambiguous in interpreting in terms of what the agency was interpreting, the federal court evaluating that regulation could essentially defer to the agency's interpretation of that statute. So it took power away from the courts and said, hey, if there's some ambiguity in this statute and you acted reasonably in your interpretation of it, we're going to defer to your expertise in this area. And we won't step into your shoes as the court. We'll allow the agency's kind of experience to kind of prevail, and we'll agree that interpretation was accurate, that was okay. And the Loper-Bright case, by the way, this essentially allowed federal agencies to expand their role. We know that federal agencies, just from experience, we know that federal agencies have grown significantly. And like I said, rules are small, but regulations are large. Well, in Loper-Bright, this just happened last year. The Supreme Court ruled that courts no longer had to defer to the federal agency's expertise in interpreting a statute. And so now the court itself can exercise its own independent judgment in evaluating whether a statute was interpreted properly by the regulation. So let's go to the next page. So there is something unique about Loper-Bright. This started as a fisheries case, right? But there's a rule in this Loper-Bright case that the Supreme Court decided that said, look, if a statute like ERISA, the Employee Retirement Income Security Act, if a statute like ERISA especially designates the agency to create rules, then there is sort of this presumption that agency acted reasonably. So in other words, it sort of carves back on the general premise that a court can just kind of step into the shoes of the agency and make its own decisions. And instead, if the federal law actually provides power to the agency to make law or to make rules, then the court is supposed to go through a different evaluation, determine whether or not the agency acted constitutionally, determine whether the agency acted within the scope of that delegation, and did the agency act reasonably in creating this rule. And this is stuff you're not going to have to remember at all. It's just to give you an understanding that, yes, Loper-Bright did expand the power of the courts to essentially step into the shoes of agencies and overturn an agency's decision with respect to implementing a statute. But in cases involving ERISA, the courts have more restricted power and their responsibility is more limited. And so let's go to the next slide. So I'm just going to kind of sum up. Loper-Bright essentially expanded the role of the court, cut back on the ability of agencies to issue regulations. Courts can step into their shoes. But in cases like ERISA, it's not going to be probably as significant a change because the Department of Labor was given authority from Congress when creating ERISA to issue regulations. And so that's the kind of the way you should approach this, that yes, Loper-Bright is interesting and it does expand the power of the courts, but will it really have that much impact on the changes in federal laws impacting benefit plans through ERISA? Go to the next page. Yeah, so there's something for everyone. And we've seen cases that have taken Loper-Bright and gone different directions, and we're going to talk about those cases. But essentially what I foresee happening is that Loper-Bright will create new opportunities for litigation, and there'll be new challenges, but it's not going to make too much of a difference in ERISA just because of this limitation that the Supreme Court issued. But let's talk a little bit, and we'll talk a little bit about the fiduciary rule, ESG, mental health parity. These are recent regulations that I'm hoping that many of you are relatively familiar with, and I'll go through and explain what these rules are. There's the ERISA fiduciary rule, which is a retirement plan rule. There's these ESG rules around investing in ESG type funds and 401k plans, and should plans be offering ESG funds and 401k plans. And then there's mental health parity. And we'll go through all of these things. We'll talk about them. I'll explain what they are, and then talk a little bit about how Loper-Bright might impact what's going to happen to the regulations that kind of enforce these rules. So let's go to the next page. So starting off the fiduciary rule. This is a 401k rule that essentially, it's been around a long time. It has a sordid history. The first fiduciary rule was issued actually by the Department of Labor in 1976. So if you know anything about the history of ERISA, that was very, very early on in the history of ERISA. Essentially, this regulation has been around for almost the entire time ERISA's been around. And what this rule has, so it's been around for 50 years. And originally, this rule essentially limited the circumstances when a financial advisor could become a fiduciary to a 401k plan. This is a big part of 401k committee life, is understanding what my role as a committee member is versus the role of the financial advisor and what the financial advisor is providing you in terms of guidance. And a lot of people just assume that a financial advisor or consultant that's advising you is a fiduciary. And that's probably true today, but if you went back to 2014, 2015, very, very few consultants, very, very few financial advisors assumed fiduciary responsibility when providing investment committees advice regarding the investments in their lineup. And so there's been this significant emphasis and effort within the fiduciary kind of history to clarify when a financial advisor or any service provider is a fiduciary. And originally, you had to have a contract. So the contract had to essentially acknowledge that the financial advisor was a fiduciary. And then you also had to have this regular course of conduct that the financial advisor was regularly providing advice, so that it was essentially obvious to everybody that the individual was a fiduciary. One, there had to be a writing, and two, there had to be this conduct. Well, that doesn't really reflect a lot of the interactions that people have with financial advisors in the 401k universe today. And the Department of Labor strongly believes that even a single point of contact, even a single point of discussion with a financial advisor regarding like a rollover, for example, from a 401k, could create a fiduciary relationship. So there's been this kind of tension between different administrations on exactly when should a financial advisor become a fiduciary. So the Obama administration issued 2 fiduciary rules that were struck down or withdrawn. Okay, then the Trump administration issued a fiduciary rule, which was struck down and withdrawn. Then Biden issued a fiduciary rule that was struck down, and it has yet to be withdrawn, but that's where we get to Loper-Bright. Okay, so now we've got this sordid history back and forth, and immediately after Loper-Bright was decided, so in like July, Loper-Bright was decided in June 2024, July 2024, 2 different federal courts in the District of Texas issued stays of enforcement on the fiduciary rule that the Joe Biden administration had published. And that's where that kind of stays today. So let's go to the next slide. The courts in these 2 federal cases in Texas essentially concluded that the Biden administration's Department of Labor, so the Department of Labor working kind of at the direction of the Biden administration, had overstepped their boundaries in issuing this rule under the fiduciary rule that essentially said that, you know, a relationship with a fiduciary could be created through a single point of contact. Like, it just didn't require an agreement. It didn't require this ongoing regular relationship. So the Biden administration fiduciary rule created more fiduciaries. It essentially created a whole lot more fiduciaries or potential fiduciaries because of this rule. And the federal courts in Texas concluded that under the Loper-Bright standard, because these cases were originally issued by the Biden administration, assuming that Chevron was the law, that there was this deference that would be provided. Well, under these federal courts in Texas concluded that under the Loper-Bright standard, that the Biden administration regulation would likely be struck down because it was just too expansive. Nowhere in ERISA could you find this concept that a single point of contact created a fiduciary relationship. So that's where we stand today. And what does that mean for us in terms of where's this going to go? Well, first of all, the Trump administration recently announced that it was appointing Daniel Aronowitz as the Assistant Secretary of Labor overseeing the Employee Benefits Security Administration. And Aronowitz has been an active, vocal proponent of Loper-Bright and a proponent of restricting agency power and regulatory authority. So we think that it's more likely than not that that the current fiduciary rule issued by the Biden administration will be withdrawn, primarily because these court cases have concluded that it was already an overreach. So my guess is that you will see a withdrawal of the fiduciary rule and sometime during the Trump administration, reissuance of a new rule. Next slide. Okay, ESG. I saw some kind of semi-confused faces when I mentioned ESG. So ESG is this concept of the environmental social governance concept that essentially, as it relates to retirement plans, can a fiduciary committee that's selecting a 401k lineup include funds in that 401k lineup that are committed or focused on advancing environmental, social, or governance issues. And ESG is like, if you said, well, what does ESG mean? You'll get hundreds of answers from hundreds of different people in terms of what ESG actually is. But it's important for committees to understand that in the context of selecting an investment fund, the ERISA rules generally require that the fiduciary selecting those funds focus only on the benefits of the participants of the plan and primarily focus on the economic return or performance of the fund. And so what happened is the Biden administration, when they took control or when they took office, they withdrew Trump regulations that essentially said you can only rely on what they called pecuniary benefits that a fund will perform. And pecuniary is financial. So under the Trump ESG rules, plan fiduciaries could only focus on the financial economic return of the fund. The Biden rule came out and said you can take two funds, one fund that's not ESG focused, one fund that is ESG focused. And if for all intents and purposes, the financial economic return of those two funds are equal, then you can choose as a committee other things or look at other things beyond the economic return to determine whether or not a fund is appropriate for your 401k. That's the Biden rule. That's the ESG rule under the Biden administration it's called the tiebreaker rule. Can you have two equally performing funds, one with ESG interests, one without, and then can you select that ESG one based on something other than economic return? And according to the Biden administration, you could. Okay, so this case was originally decided under the Chevron standard, remember the deference standard. And then when Loper-Bright came out, it was remanded back to the federal court that it started in, again, in Texas. And this is important because when you think of like where parties typically go to file lawsuits against regulations, against the DOL or whatever regulation, they often choose a district court or federal court in Texas because they tend to be kind of more like restrictive and authoritative towards agencies. So this court actually what was expected to take a much more conservative perspective and strike down the Biden ESG tiebreaker rule, expected to strike it down. It actually looked under Loper-Bright and concluded that the regulation that the Department of Labor issued under Loper-Bright doesn't contradict the ERISA and the standards of ERISA to focus on participants' economic return, because there will be circumstances when tiebreakers may exist, and there's nothing in ERISA that precludes you from looking beyond to decide whether or not a particular fund is appropriate. And so this case, which was in a Texas court, was expected to be struck down under Loper-Bright. The court in this particular case ruled that the law, the Biden administration's tiebreaker rule, was acceptable under ERISA. Okay, let's go to the next slide. So mental health parity. This is just a growing, and I know some of you that I work with regularly, this is a growing area of interest for the Department of Labor. For the longest time, the Department of Labor is primarily focused on fiduciary issues and compliance issues on the retirement side, all the fees, and are you charging an appropriate fee, and have you hired a fiduciary or not? It's like so much litigation was focused on the retirement side. Well, the Consolidated Appropriations Act added a new rule that plans now have to review their if they offer mental health services at all in their health plans, the health plan law. If they offer any mental health services at all, they have to evaluate whether the mental health services are more restricted and subject to additional barriers that the medical care is not subject to. And so there's these tests that you run and all this different evaluation. But what the Consolidated Appropriations Act created in 2021 was an obligation for employers to conduct an evaluation, and it's a fairly complex, detailed evaluation to evaluate whether there's restrictions and limitations on access to different types of mental health services, that those restrictions don't exist on the medical side. So like to illustrate, does a plan that has a medically necessary requirement in order to get health care, so it's a health plan, and in order to get health care, you have to have a medically necessary service provided. And does that plan create a definition or a process for deciding whether something's medically necessary that's different on the medical side versus on the mental health side? So if the medically necessary definition on the mental health side is more restrictive or complex, it creates additional burdens, that violates the mental health parity law. Okay, and that all started in 2021. You had to do this report, and there's now a fiduciary requirement to certify that that report is accurate and complete and complies with the law. And that all came out in a regulation that was issued last year or late in 2023, became final last year. And that's the mental health parity rule for non-quantitative treatment limitations. And let's go to the next slide. So this case has also been challenged by the ERISA Retirement Committee. And it's this case in, actually, maybe I need to go back to the previous slide. Can we go back a slide? I skipped. Yeah, in 2025, it was just filed. So this case was just filed by ERIC just a month and a half or so ago. And they're suing to enjoin enforcement of this obligation to create this report as to whether or not your plan complies with mental health parity. And so the case, interestingly enough, argues that the Department of Labor overstepped its bound in creating these obligations to create this regulatory report, that this report's nowhere found, or obligation nowhere found in the statute. And the certification requirement to certify that by the fiduciary that the report is complete and complies with the law is not found in the statute. So that's what the court is, the ERIC, this committee is suing to enjoin enforcement of this report requirement. Let's go to the next slide. So this was just filed in January. The Employee Benefits Security Administration has until March 18th, which is 4 days. So this is hot off the press to respond to this complaint. And I guess the issue that we would be looking at is, is this something that the Department of Labor is going to continue to pursue under the Trump administration? And so based on kind of the direction that they've gone in terms of selecting the leadership in the EBSA, we think that it's highly unlikely that this regulation will stand, and that in response to this obligation to file a response to the litigation on March 18th, the Trump administration is likely to withdraw that regulation. We don't know that, but that's certainly a possibility. Another thing of note, that the primary lawyer, the senior lawyer representing ERIC in this lawsuit, is the former Secretary of Labor, Eugene Scalia, who is a Trump person, somebody that was appointed by Donald Trump. Okay, so let's go to the next slide. Get some water. So what's our take? Well, first of all, there's something for everyone in this. Obviously, Loper-Bright expands the role of the courts, but then again, it kind of limits that. And we've seen already that, in the fiduciary case, the federal court in Texas jumped on it, and under Loper-Bright said, hey, we think that this rule, the fiduciary rule issued by the Biden administration, is unlikely to survive scrutiny, so they issued that stay. But a similar court in Texas in the ESG case concluded that no, that was reasonable, that the Department of Labor acted reasonably. So we think that what's going to continue is probably kind of what's been going on historically in terms of like new administration issuing new regs. Courts are going to be, you still have the same forum shopping, but we do think that there's going to be a bit of change from this. Let's go to the next slide. So the thing that I think is the most frustrating for employers, fiduciaries, and plan sponsors is kind of the back and forth. And will Loper-Bright change that dynamic? And I think that it will in the margins. And part of that is that the Department of Labor and other agencies will think, there's a higher standard. There's more authority for the courts to strike down. So it may kind of roll back some of the kind of advocative type regulations, and it may be a little bit more kind of mainstream. So there'll be like a normalization of regulations being issued by the agencies, knowing that the courts now have more authority and more discretion to determine whether or not their regulation was reasonable under this Loper-Bright case. And I also think that it's going to, and as a lawyer, of course, I'm gonna kind of think this way. I think that courts are going to become more involved in sort of setting the standard of what constitutes good regulation, because there's just going to be more opportunity for the federal courts to essentially establish what we call precedents. And as precedents is established by different courts making decisions, it's much harder in the court system for one court to overrule the precedents that existed. So think about the other cases where there's been a precedent established. It's just far less likely that there's going to be a change to that. So we're going to see a harder, more challenging role for the agencies to essentially create new regulations once this precedence is established by the courts under this Loper-Bright standard. I think is that it? All right, so that's it. Any questions for me?
It was very interesting. Very, very thoughtful.
Good. I try and keep people from falling asleep during my presentation, so hopefully you didn't fall asleep. Okay, we're going to do a 10-minute break. Thank you.
Are we ready? I see Lisa with those slides. Activity can't tell. Thank you. We were trying to talk to the group who were muted. Oh, is she muted right now? Can you hear me? Can you hear me?
We can hear you.
All right, well, we're ready when the slides are ready and when the other groups are ready. Okay, that looks like that's my cue to start. Okay, good morning, I'm Beth Nedrow. I'm in the Billings, Montana office. And today we're going to talk about who's the employer. And this is one of the situations where it's a topic or a concept that on the surface you would think, well, that's not hard, you know, like a topic we're not going to cover today, but which is in the same vein as what is compensation. And you start digging into that definition and it gets very complicated. Today we're talking about who's the employer. And it can get pretty complicated these are the types of situations where we've run into issues, and it's something that requires a little bit of analysis and working through. Parent, subsidiary, other conglomerated, sort of complicated organizational charts. You know, if you're in an organization and you circulate a chart that has, you know, dots and bubbles of different groups that are related or operating, you're going to want to pay attention. PEOs, this is a professional employee organization, or leased employees, or staffing agencies. And I know there's differences, and I know there's folks who use PEOs or PEO organizations attending today, and I don't want to offend anybody by lumping them all under the term PEO. I know that there are differences. Entrepreneurs with unrelated operations, you know, a family business where they've got, you know, maybe a lot of institutional family wealth, and the family or the entrepreneur get involved in different operations and they're running different businesses. Also business acquisitions. So if your company buys or sells a division, sometimes that can happen pretty quickly. You know, we've had HR departments come to us and say, gee, we were told that yesterday our management bought a new company, what do we do? And so we can run into these control group issues there. Next slide. We're going to come back to why it matters and when this definition of employer comes up. But I wanted to just kind of drop these thoughts here, and then we're going to go through and talk through how you determine who's the employer. But I kind of wanted you to have in mind what our end goal is here and when this topic can come up. Number one, it's going to come up in when you decide who's eligible under the plan. Your plan will say, you know, we're talking about 401k plans and medical plans primarily, but you know, you have a blank in your plan document where you filled out the employer is blank and you enter in the entity. Well, does it cover the entities that you want it to and the employees of that entity? Who sponsors the plan? Again, the blank will say, you know, who your plan sponsor is. When you run plan coverage and non-discrimination testing, you have to be able to say who your population of employees are. In determining whether you're an applicable large employer under the Affordable Care Act, in determining whether you're subject to COBRA, you know, where there's those threshold numbers of, if you're an employer of a certain number of employee size, you're subject to one of these federal laws, you might have to be taking into account a larger population of employees than maybe you thought. In determining whether you're a MIWA, we've been throwing around a lot of acronyms today. I think it's funny how some of them we pronounce and others we use the letters. And this is one of the areas where we have a lot of the pronounced acronyms, which crack me up. But MIWA is Multiple Employer Welfare Arrangement. We'll talk a little bit about that. And then I guess another a very expensive mistake to make if you're not aware that you have a control group liability is union pension plans, and underfunded defined benefit pension plans. You can have shared obligations. So if you have any of those situations, you really want to know who your employer is. So again, we'll maybe come back and talk about some of those details, depending on how long it takes me to work through the org chart. So next slide. So kind of the easiest one, you've probably heard of the term control group. And you have to be careful when you use this term, because the tax code uses the concept of control group, and you talk about control group filings on the tax side, but there's a very specific definition of control group that applies to benefit plans. And so it's always worth, just coming back to the retirement plan, benefit plan definition in ERISA, or in the code. This one's pretty basic. You generally know when when you have one of these, it requires about 80% control. So in my little example here, obviously parent owns 100% of sub 1. They're in the same control group. If both of those entities have employees, they're going to be deemed to be a single employer. Sub 1 owns 80% of sub 2, and there's an investor that owns 20% of sub 2. Well, we've got our 80% limit there, or 80% threshold between sub 1 and sub 2. So sub 1 and sub 2 are in the same control group. What that also means is then you link all of them together. So it's a little like Tinker Toys. Like once you start putting little groups together, if one's related to another, you bring in them all. So in this chart here, we have a single employer that consists of parent, sub 1, and sub 2. It's also important, if you're looking at your company's org chart, somebody may tell you, well, sub 1 doesn't have any employees, and so they may sort of just cut that off. They may not give you that data. So when I start asking control group questions, I ask for the complete org chart, and then I say, tell me which of these organizations has employees. But you're still, let's say sub 1 doesn't have any employees, but sub 2 does. The employees of parent and sub 2 are going to be considered the employees of the same employer. Okay, so that's kind of the easiest concept. And by the way, I don't know how I ended up doing the math element here. The entry, I'm a liberal arts major, so if I make math errors, don't blame me. Don't judge me too harshly. So the next slide, please. So that was parent sub. You can also have a control group if you have a brother-sister organization. And this is where the math does get a little complicated, and it's very hard to explain this in a narrative, but I'll give it a shot. And if I mix it up, I guess the punchline here is that if you have organizations that you think have some level of common ownership, you should run the analysis. So Beth and Leslie, we want to support each other. And so we want to run a hotel and a bakery, 2 different businesses. And I'm mostly in charge of the hotel, so I'm going to be 70% owner of the hotel and 30% owner of the bakery. And Leslie's going to be 70% owner of the bakery and 30% owner of the hotel. The IRS is going to say that the hotel and the bakery are the same employer. So even if Leslie and I aren't related, you would ordinarily think there's nothing that connects them. There's a 2-step part of this test, and the first step is that 5 or fewer of the same people have to own 80% of each entity. Well, together we control 100% of each. So 2 of us own 100%. That's greater than 80. So we've met the first step. Then the next step is where it's going to be difficult to explain in the narrative. I'll say it, and this probably won't make sense, but taking into account only our common ownership. So each of us only owns 30% of each of the entities. But you add that together, that's 60%. In that second step, if you're over 50%, you've met and there's a term for it, there's a control term for it. But basically, the way the brother-sister control group test runs, they would say that the hotel and the bakery employees have to be considered the same, employed by the same employer. So where things get tricky, like if that's that can be a little bit hard, but go to the next slide. Where things get interesting, and you run into some really interesting fact patterns, is you have, I give you clear examples about, I said Beth owns 70% and 30%. Well, how do you know what Beth actually owns? Well, for starters, there's a whole set of rules where you have to attribute ownership to a spouse, and sometimes you attribute to children, grandchildren, and parents. So maybe Leslie and I thought we were going to be clever, and we, assigned some of our ownership to our husbands. We divvied the numbers out so that we didn't hit the 50% or the 80%. Well, there's a good chance that the IRS would say, that's a little too clever. We're going to consider your spouse ownership to be owned by you. This also can be tricky if you're thinking about this. What if one spouse owns, 100% of a construction business and the other spouse owns 100% of a bakery? Well, the IRS might say, there may be a situation where you have to attribute the ownership of each spouse to their other spouse, and those two, what they would think would be unrelated businesses. I mean, they're two independent business owners. So there's probably going to be a way around that. So don't panic too much if you're wondering what that you and your spouse are in trouble right now. You're probably not. But the ownership attribution can be hard to work through, and this can be really hard, especially if you work with like a family trust or a business that is keeps their ownership kind of close to the vest, and it's a little bit of a sensitive question. And if you get into asking, like the next bullet says, you have to, if you have a trust, you have to get into who's the grantor of the trust, who are the beneficiaries of the trust. And that can be kind of delicate information to get out of, say a family business, and it might change over time as generations change. So it can be a little bit of a delicate analysis sometimes to get the information you need. And also if you have entities, it's pretty clear cut if you're talking about a corporation because you look at stock. But if you know anything about other types of entities, if you've got a nonprofit entity, I think we have some hospital entities, hospital folks participated today. Nonprofit entities, you don't really have stock ownership, but you have to look at the board members, and it can be kind of complicated on determining who controls that nonprofit entity. Next slide. So that was controlled group. A lot of times if you're reading through, maybe your questionnaire with your service provider says, are you a member of a control group or an affiliated service group? You're like, man, I don't know. Like, control group is a little bit easier to understand. Affiliated service group is, again, it's a little bit of a hard concept to narrate through. I think actually affiliated service group kind of comes down to common sense. So I'm going to, again, walk you through the technical part of the rule, and then I'll give you my common sense interpretation of it. So and unfortunately, we can kind of blame the doctors for affiliated service group. And this is true. If you look in the regulation preambles, they'll explain that the reason these affiliated service group rules came about is because particularly, and it's tax planning. I'm not saying they're evil or wrong for doing it, but particularly in the health industry, they would organize, a practice for the physicians and then a practice for the clinic staff, and try and say they were, with separate ownership and not be connected. And so these affiliated service group rules came up, and they said, first of all, if one of the entities that you're looking at on your page is a service organization, and there's a definition of service organization, it specifically lists those. That's essentially a quote out of the regulation: health, law, engineering, architecture, accounting. Those industries are by definition service organizations. But then it throws in, or if capital is not a material income producing factor. Again, it's kind of common sense. Like, are they producing a product, or are they providing a service? Next slide. So you start with, okay, one of the entities on my page is a service organization. Now, is there any other entity that, and then we abbreviate these A-org and B-org. I don't know if it's going to be helpful for me to read this to you, but what you should notice is that it doesn't necessarily have to be a strong ownership connection. It's in any other a service organization that is an owner in the first service organization and regularly performs services for that service organization. Like I said, I'm going to kind of skip over all that language. I think we're going to share the slide. Well, I forgot to ask that question, but or we can produce this definition for you if you like. Again, this is going to kind of, I think it comes down to common sense. If you're looking at a group of organizations, and I just looked at one last month, where it's an investor group, and they understand that all of their, in all the investor groups, investment companies are related, but then they have this organization sitting out there that doesn't have any common ownership, but it handles all the payroll and it does all the bookkeeping for all of these other organizations. And just from your common sense, you look at it and you say, they're connected, like just your gut tells you. Now, you might be able to walk through it and determine, you know, I might be wrong, but your alarm bell should go off and you should say, we should ask whether we are an affiliated service group. So control group, affiliated service group are mathematical tests in the Internal Revenue Code. And I don't have a sum up slide, so that's what I'm doing here now. A lot, you start with your common sense gut, and then you run through the math, and you're probably going to run into a lot of complicated, how you attribute stock ownership. Do you attribute it to spouses? Do you have, you know, trust ownership? That kind of thing gets confusing. The next slide, please. So PEOs, employment agencies, leased employees, staffing employees. There are a lot of different flavors of these. What you have to remember is that when the IRS and Department of Labor are holding an employer accountable to how it treats its employees, there's no statutory definition of employee. What the agencies will say is they go back to, and I don't know if anybody's curious about this, but common law is the term that lawyers use when it's not in writing, but it's something that is developed over time. Some of it honestly goes back into, you know, the laws that we inherited from England. You can get really complicated, and, you know, it can be kind of an interesting history lesson in how common law has developed. But what when the courts and the agencies are saying, who are your employees, and you say, well, how do we determine who's our employee? It's a facts and circumstances test. It's what is, over time, what does the concept of employment, how has it evolved, what does it mean? And generally it comes down to, if you've gone into this, it's a control. Who controls the terms and conditions of this person's employment? Who supplies them with tools? Who decides what their pay is? Who decides whether they can be fired or what vacation they have? And so what the problem that we had with lease employee arrangements for a while, as this business model developed, is practically the reason why employers go to a staffing agency is they want the staffing agency to be the employer. The client organization, generally, that's what they're trying to offload and outsource. But the agencies and the common law would say, well, you say you've outsourced it, but you still, client organization, are controlling the terms and conditions of that employment. So we're going to say you're the employer. So as it's evolved, the regulators, and this is both on a state level and a federal level, have generally said it's okay for you to enter into these types of contracts, and you can say that you're co-employed. So the employee actually is employed at the same time by the staffing agency and by the client organization. And that lets you kind of, you know, through those two hats, it lets the staffing agency determine, you know, who's the sponsor of the 401k plan, is the medical plan EWA, is the employer subject to COBRA. There's no one single answer to who is the employer. It's either going to be, like I say, it's either going to be co-employment, or the staffing agency will say, look, we're going to do these services for you, but you're still going to be the employer. will help you comply with your responsibilities and set you up for that, but it's still going to be you're the employer. So there's no one right answer. There's no one clear situation here. The point is you need to be clear. You know, the staffing agencies are professionals, the PEOs are professionals, that's what the P stands for. And the contract should pretty clearly walk you through what the situation is, what the rules are. Next slide. A couple thoughts on mergers and acquisitions. In just generally in the world of mergers and acquisitions, we think of two different buckets. If it's an asset purchase, you're generally hiring the employees as new employees on day one. They're going to be your employees on day one. And so immediately you're going to have to think about things like service credit and eligibility. Again, this can be pretty tricky if, you know, management comes to HR and says, hey, we, you know, bought a group last week, and you need to onboard 50 new employees as of yesterday. and you look at your 401k plan and you say, we have immediate eligibility. How are we going to handle that? You know, if you can get a heads up on how an asset purchase works, that's a good thing to do. And think about in advance whether you're going to give them service credit or eligibility and how they fit in the benefit plans. A stock purchase or a merger is kind of interesting. And the concept there is, if you imagine in your head the slide where I had sub 1 and sub 2, well, what we're talking about is we just acquired sub 3. And it has, you know, it has its own identity. It has, you know, let's say it's a corporation in its own right. And when it comes over as sort of a already existing organization with all its own employees. And you have to think about whether your plan document says that all employees of the control group participate. Do new employers have to sign on? They're going to be bringing over, if they had benefit plans that new entity, that the acquired entity sponsored, they're going to be coming over. So you've got to be thinking about, does the acquired company's plan, you know, if it has an expansive definition set that says, you know, immediately, bam, on day one, all employees of the control group are eligible to participate in that company's plan. You just automatically, the IRS would say, should have made all of your existing employees participating in that newly acquired subsidiaries plan. So again, that's an absurd result. It's one that, you know, there are ways to fix it. You know, we go back to Alex's presentation on, you know, would we go through VCP and get a retroactive plan amendment that says, no, we really meant to keep them separate. Yes, that's what we do. Okay, the next slide. I covered this one earlier a little bit, so let's go to the next slide after that. And just in a quick minute, I'll just talk about how some of the exceptions, mostly because I like to say QSLOB. Of all the acronyms we have, that's been my favorite all the years. So there's an exception to, especially for the family-owned businesses. The IRS has a rule. It's called a qualified separate line of business, and what you do is you file with the IRS and say, yes, we know that we're a controlled group, but we have this bakery and we have this hotel, and they really are different businesses. And you should allow us, IRS, to treat them as separate employers. And there's a multiple prong test. One of the prongs that we've seen be a problem in the past is that each entity must have at least 50 employees. So it has to be a substantial enough business that you can meet that definition. There's also a special transaction testing transition rule. So if you do want to maintain separate benefit plans for separate 401k or retirement plans post acquisition or merger, there's a transition rule that you could follow. Those are the ones that we see most often. And I think I'm out of time. So just the next slide was just going to be a review of why it matters, but maybe in the breaks, if there are fact patterns that I just covered that people want to talk about in these particular situations, we could cover that. And am I muted? Next is Brenda she's in Salt Lake today.
Thanks, Beth. Yes, I'm Brenda Berg. Got to talk to you a little bit already, and I'll be turning back and forth here a little bit. But I'm an employee benefits partner in our group. I've been an employee benefits attorney for over 25 years, typically out of the Denver office. I get to be here today, so I'm excited to be here with all of you. And I often work with fiduciary committees as well on all of their fiduciary oversight functions on retirement plans and health and welfare plans. Yes, I should look this way more. And for that purpose, one of the things I've been working with a lot of them lately are oversight of their managed accounts. So let's go to the next slide. Let's start with first, what are we talking about when I'm talking about managed accounts? What are they? Not every plan has them in their lineup. But if you have, you know, the financial engines, sometimes it's through Fidelity, the other typical provider is Morningstar. It's a personalized financial advice service. So employees can sign up for this and basically say, manage this for me, handle their account. Participant no longer goes in and makes investment elections. Instead, the managed account provider decides which funds they're going to be in. So it's a more personalized service. And I've showed it up here next to target date funds because that's typically, you know, offered alongside, but it's another level of do it for me, but it's a less personalized level of do it for me. And you can see the contrast there. Managed accounts or target date funds can be used as your qualified default investment alternative, meaning somebody signs up for the plan and doesn't make investment elections, or more likely you automatically enrolled them, didn't make an investment election. So where do you put them? There's fiduciary protection if the type of account satisfies these requirements for a QDIA. That's one we have to say the letters. It's pretty hard to spell that one out. But if it satisfies that, you could be into either. The Department of Labor has approved either of these, but most of you probably have target dates as your QDIA. In a managed account, it has, like I said, it's customized. So I think that's why it makes sense. Usually it's not the QDIA because the people who get defaulted are people who weren't paying attention. So they're less likely to go in and customize. But it can be customized with many data points. It should be customized with many data points because the managed account service has an extra fee. And so you should be monitoring this fee. And it'll be like 25 basis points or something like that on top of your regular investment management fees and on top of your record keeping fees. And again, not every plan has these in their lineup, but a lot of plans are looking at whether they should have them or, and also if they have them, how should they monitor them? So there is that management fee, but the data points that can be added in, the plan can give some of the data points. It can give the compensation, the savings rate, but other ones such as maybe you have a different risk tolerance. So you put that in there as your data, and then they might be more conservative than you would be in a target date fund, which uses one data point, which is just your age, expected age of retirement. They usually assume you're going to retire at age 65. Other data points that could be used on that are other assets or other investments that you or your spouse has, or perhaps you have some other assets that are super conservative, like a cash balance plan or a pension plan. So maybe you want to be more aggressive in your 401k plan. So in theory, at least, it is a more tailored solution versus a target date, which is going to be just the one data point, doesn't have the additional management fee. It is going to be one series. There's a lot more options out here that plan sponsors can provide on their target date funds, a lot more providers. But the plan sponsor for a target date fund would evaluate, they're going to pick a series. It's either going to be active or passive. They need to figure out which one is right for their participants, what their demographic. Some will be more aggressive than others. And so they would pick whichever flavor is, but then that's the only flavor in the target date that's in the plan. Okay, next slide, please. So we're talking about the managed accounts, and a lot of plans that have had them for a long time in their plan, they just kind of set them and forget them, I would say, weren't paying that much attention. And they're starting to need to pay more attention, partly because of the litigation, partly because people are just learning more what's going on in this plan. So participant brought a case because here's what happened to her. She was defaulted into the managed account program. Again, didn't pay attention, got defaulted into it. That was their QDIA. In fact, it happened to her twice. She was in it for 2 years, and I guess must have elected to be moved out. And then I think the fiduciaries must have done a re-enroll, which sometimes happens, right, with the QDIA. And so they said, if you don't come in and change it, we're going to put you in again. Again, she's not paying attention, got put into it again. So now she at some point realizes, wait a minute, I ended up paying she was somewhere in the range of $298 to $348 a year because of those extra fees that get put on managed accounts. And you know what? If you would have put me in the target date fund, I would have only paid $24 to $29 for my record keeping fee, because there really is a significant additional fee on these accounts. So she brings this case, trying to make it class action. It's a very recent case I filed last May. And her claim here is that she was never asked to personalize it. She never did go in. Obviously, she got defaulted, never personalized it, never added any other factors that would make it more personalized. So really, they're probably just working off her age, just like a target date fund, and didn't meet with it. Then also in the class action, turns out 2/3 of this is I believe an engineering company. Apparently 2/3 of their participants were defaulted into this. And of those 2/3 did not personalize. So they had 7,000. It's a really big plan. For allegations there, without personalization, these are essentially expensive target date funds and higher fees, which added up to, for all the class, about $23 million according to plaintiff's calculations. And she also showed worse returns when she compared 5-year returns, to 5-year returns, just based on her lack of personalization. So this is what we're looking for. This has come up in some other cases too. Let's go to the next slide. Those are her facts. And so she brought a claim for breach of fiduciary duty. Not sure if they heard. Next slide, please. And she brought this class action, or purports to try to bring a class action. And her claims were breach of the fiduciary duty of prudence, that it wasn't prudent to have the managed account service as a QDIA, or maybe even in the plan. As stated, the duty of prudence is one of the ERISA fiduciary duties, stated at the bottom if you're not familiar with it, but it's basically prudence under the circumstances. And the best thing for defending against a duty of prudence claim is your process. So she said they didn't have a process, a good process. They didn't show a good process for this. They got us into defaulted into it, had excess fees. And then also they didn't have duty. They failed their breach of duty to monitor. Because even if you point it to another fiduciary, and these managed accounts are fiduciaries to the participant with respect to their accounts, you still have to monitor them. And so they said there was no process to monitor. You didn't check to see if we personalized or anything like that. And again, a typical breach of fiduciary claim, they will typically bring it against the committee that was the fiduciaries, but also against the company and the board of directors. They'll try to, at least if you don't have it properly set up with your committees, you won't get, otherwise you'll get dismissed if you do have it properly set up. Anyway, saying that they failed to properly monitor. So that's how she brought the claim. If you can go to the next slide, please. So what has happened with this? Well, good news for plan sponsors, it did get dismissed, okay? So first, it got dismissed once, and then the court said, you can go back and refile, because what I want to see is a meaningful benchmark. He said, you're comparing apples to oranges. As we saw in the chart, target date funds are not the same as managed accounts. And so he said, you can't compare the fees in a target date to fees in managed account. And also, it was dismissed because he said, these are personalized. So you can't compare a target date. Well, of course, as we know from the facts, they weren't personalized because they never personalized them. But that's what this court was looking for, was some sort of comparison of managed account to managed account. So they actually dismissed it again just a month and a half ago, because they amended the complaint and said, still, you didn't show us a managed account. Now, so that one, that claim did fail. However, you can go to the next slide, please. Does that mean you don't have to worry about those? No, of course not. That's just one court case. But also, this claim is coming up in other cases. First of all, this was worse facts because it was the default fund, right? But it's coming up in cases even where it's not the default fund, saying you still didn't monitor it, you didn't have a fiduciary process to ensure that we're getting the value out of that. There's another recent case brought by the big plaintiffs firm that pretty much spearheaded all of the fiduciary fee litigation. So they'll probably come up with a way to get around that, because the claim these other cases are saying, it's not, you don't compare managed account to managed account. The question is managed account to target date. So if they get a court case to go with that, there'll probably be a different result. So those cases are still out there. And then also another line of reasoning that's coming up on managed account cases now is that you should know of is, guess what? The managed account provider pays fees back to the record keeper. So all of those extra fees that are being paid, usually about half of it gets kept by the managed account provider and half of it goes paid back to the record keeper. In this AT&T case, it was pointed out that there was never a process to evaluate those fees that were paid. And so that you should consider those fees that were paid. Now, I'll say that from a record keeper perspective, I think they would say that's not record keeping fees, because remember, you can't pay more than reasonable fees for record keeping, or that's a breach. So that's why you need to consider all fees. But the record keeper would say, well, that wasn't for record keeping, that was data connectivity or for some other, just being on the platform. But it makes bad facts. Back in the case we were just talking about, they said there's a powerful incentive for the record keeper to sell these. And you may have noticed in some of your RFPs, sometimes even the record keeper will give you a lower record keeping fee if you put in a managed account service, especially if you'll do it as a default fund, because they're getting more money, right? So it just makes sense. I mean, they have to make money, but we have to understand where they make money. And so that's the other line of thought is we need to evaluate, make sure you think about that. Probably aren't going to get a lot of information from it, but that's the other line of cases coming out on managed accounts. Okay, next slide, please. So what do you need to do? You're on the committee or you're advising committees or if you're a fiduciary, any sense on these plans. First question, what's your value proposition? Why do we want a managed account? There can be a lot of good reasons to have managed accounts in your plan, but why do you want them? What is your demographic? Why is this something about this that's better than target date funds? So think about that. Next slide, please. Start there. And that's when you're thinking about your goals. And these might be some of your goals. Now, when I was talking about what a managed account is, a lot of times it's an algorithm. It's a robo-advisor. So it's not personalized. I said personalized, but it's not a person. So it's a lot of times. But there is another flavor where it actually is a person sitting down, giving you the hand-holding to. A lot of participants really want that. So maybe that's what it is. Maybe it's you want them to be able to be more engaged for that. Maybe you really feel like you have a demographic that has a lot of other assets that really needs those taken into consideration in their retirement plan goals. And those could all be really good reasons that you might want a managed account service. Maybe they do get higher returns, but you need to think about, does the product that you're looking at meet those goals? So that's the first question, why does it make sense for this demographic? Okay, next slide. And you might even have it as a default fund, by the way. That is not per se wrong. As I mentioned at the beginning, the Department of Labor has sanctioned that as use of it. But I think it is a tough call because these are people who aren't engaged. And you almost never get value from these unless they're personalized and put data funds in. My opinion. So you want to understand what kind of managed account do you have or are you looking at? Is it a personal one or is it robo-advice? Both are fine, but different goals. What's the fee structure? Is it a per participant? You come and they charge, it's always going to be charged pretty much to the participant account. Usually it's basis points of the assets, and then up at a break point, like 100,000, it might go to a lower basis points. It's typically like that. So you'll want to compare that to what you could get with other providers. Now, usually on the record keepers, I think most record keepers only have one or two even available on their platform. So that it's a lot of times your choice isn't going to be to another managed account provider. It's whether to provide one at all. But you look at the fees and try to find out if you can figure out the fees that are paid between, with the record keeper. What investment funds are used in your managed account service? Typically in the robo-advisor style, they will just be using the investments that are in the plan lineup. So they'll pick those. Some of these robo-advisor ones also have a strong bias towards passive funds. That might be fine, but why are they paying an extra fee when passive funds are very cheap fees to go into? Maybe they could do, maybe this isn't the way to go into those funds. So these are just things to understand, not one right answer or not, but which data points are collected. Do they go out and reach out to the participants to make sure they're personalized? How often do they do that? Obviously, our financial picture changes over time. And you can get data from your managed account provider that will show how many have personalized. What have they personalized? Then you will also look at, did anything change when I added different data? If you say that you want to be aggressive, and I say I want to be conservative, but we're both the same age and we still get put in the same funds, did that even matter that we got that data? So, and that's true. Or if I say I have a whole bunch of other assets, but it didn't have any difference in the outcome, those are things you can look at and see if personalization even made a difference. Because what you're trying to see again is, did they meet your value proposition? You can look also what other services are provided. Your provider will also be able to help you with this. They can show sometimes that they've encouraged people to increase their contributions, for example, and they have a lot higher contributions of people that are in this. That's kind of chicken or egg, but on the other thing they can do is sometimes they help you give advice on payout timing. So that's a big issue for retirement plans now, is this decumulation stage and how to deal with that. And these services can help with that. You do want to know if they are using the participant data for other cross-selling purposes, especially if it's data they got from the plan. There's a lot of litigation that has allegations of misuse of participant data and says that a lot of settlements that say the plan sponsor should be putting that in their services contracts, that you cannot use participant data that they've obtained from the plan. Because of course, providers would like to say, oh, you've got these other funds, I'd like to sell you a life insurance plan and so on, and a mortgage. And so those could be good services, but if you're getting, especially if it's coming from the plan data, you want to be careful of that. Usually they will say it's coming from the participant, and that might be an okay distinction. So these are some of the things that you would try to figure out about your managed account provider. Okay, next slide. And then figure out if you do have better outcomes. Again, go back to your threshold question of your goal. Figure out if you can see about all that information you determined, does it look like this is adding value? You can benchmark it against other managed account providers, against plans of similar sizes. It's difficult to bench against the target date results, but you should try to do, you should do so with the caveats that you know you are looking at apples and oranges. You may be getting more conservative results because they told you something that they wanted more conservative results. But your financial advisor should be able to help you evaluate that, and the service providers can as well. And you can figure out who's using it and whether you're getting any other benefits out of it as well. And I recommend you do this probably annually. Okay. Next slide, please. And I've mentioned the service contracts. All of these things would be things that you would cover in your services contracts. I do feel like service contracts used to be something of an afterthought, and now, as I think Kevin alluded to it earlier, there's so much that we can do right on the front end of things to make it so that it makes it easier for you to monitor things later and to know what they're doing. But we can't forget, like, the number one rule of fiduciary duties is document your process. As I said, process is the best defense for a breach of fiduciary duty claim. And so you want to show that you did all of these steps. Now, typically, if you add it to your fiduciary calendar, meeting whatever your committee does every year, maybe once a year, you'll have it right there. You'll get reports from your financial advisor and from the service, and your record keeper. They'll be able to show, and you'll be able to, all you have to document, that you looked at those reports and that you discussed it. You don't have to put all these specifics, but that you continue to determine it has additional value. And if you do get sued, that would be a major defense for you. Okay, I think that's it. So maybe we can stop being a little bit early on that. So now, of course, I'll have open to questions on that. And also, we're going to have lunches. I think we must have lunches out there. Yes, we do. Everybody, please grab lunches. And then we're hoping, if you want to stick around, I'd love to take questions or just discussion, or if you want to discuss with each other. And everybody in their own offices will do that as well. And if you need to leave, we also understand that. Feel free to grab lunch and go. So thank you so much for coming. We'd be happy to help you with any of these issues or anything else. Yes. Thank you. Thank you. So get talking so fast. I'm a best doctor. Really, I thought you were doing else. Yeah, I know, right? That's 5 minutes today. Move my one. That's on the go take class. I think there is. Serena, there's parking validation, right? Yes.